All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. This is the time set for argument in CAO versus Dorsey Investments. 1 CACV 210275. Counsel, we have read and considered the briefs in this matter and discussed the matter at conference this morning. Both sides are allotted 20 minutes to present their case. These arguments are being recorded, so if you please state your name and the party you represent before you begin. And with that, Mr. Frazier.
Good morning, Your Honors. May it please the Court. My name is Eric Frazier. I have with me John Bullock. We represent the plaintiffs Jay CAO and Fraser Shaw. I'd like to reserve 3 minutes of time for rebuttal. I'd like to start with a really simple premise, which is that this statute gives the majority owner the guaranteed right to sell the property, but it does not give the majority owner the guaranteed right to be the buyer. And that's a really important distinction, because here everyone proceeded as if Dorsey Investments was the only possible buyer. And that misconception is at the root of all the ways in which the statute was misconstrued. Thinking that Dorsey Investments was the only possible buyer is what led people to think that the statute authorizes selling less than the entire development. Because if there's only one possible buyer and they already own most of it, why would you have to put up your own property for sale? But that's what led to the crazy outcome in this case. The only owner who voted to sell was Dorsey Investments, and it was on the other side of this transaction. It was acting as the buyer and had none of its own property at stake. It was voting solely to sell someone else's property to itself. And everyone whose property was actually at stake voted against the sale. The only part of this entire statute that authorizes a forced sale is the first sentence of subsection C, which requires selling all units.
It doesn't say that. It says a termination agreement may provide that all common elements and units of the condominium shall be sold following termination. It may provide for all. It doesn't require it.
But the permissiveness in that termination statute is that the termination agreement may provide for a sale. It doesn't have to. So the permissiveness...
No, it says it may provide for all common elements. So if it may provide for all, it assumes that it may not.
I don't think so, Your Honor, because if we take a step back and think about this, without this statute, I think everybody agrees that Dorsey Investments would not have the right to force a sale. And so we have to find something in the statute that gives them this right. And the only part that gives them this right is the sentence that you just read. And you're right, it authorizes, it says may, permissively, it may provide for the sale of all units. There's no part of the statute that says it may provide for less.
I'm sorry, if I just have one more question.
You go right ahead.
It says, and then the second part of that very same subsection C says, if pursuant to the agreement, any real estate. Well, if it was all, wouldn't it say the real estate is to be sold?
So, no, and again, I think if you take a step back and remember that without this statute, nobody has the right to force a sale, you have to look for something that actually authorizes the sale. So that second sentence does not authorize any sale. All it talks about is what are the consequences of a sale if the termination agreement provides for one. And I think, again,
we're doing a lot of jumping jacks here, or somersaults, or whatever you want to call it, because it does provide in the first sentence, may provide all, and then the second sentence says, pursuant to the agreement, any. Definitely, to me, that contemplates that it can be something less than all.
And would you, sorry, go ahead, I'll let you.
Yeah, I think for that interpretation to be right, there would have to be some part of the statute that authorizes less than all. And I don't think that second sentence, I understand what you're saying in context, but there's no part of the statute that actually authorizes selling less than all. That second sentence does not authorize selling less than all. It just discusses what are the consequences.
Well, then why say any at all? Your interpretation reads any right out of that statute.
No, I don't think that's true, Your Honor. I think, in normal conversation, you might say, if it's going to sell anything, here's what it has to do. And I think that's what the statute is telling us here. And that makes a lot of sense, again, because it avoids the situation where you have people voting on selling other people's property. That's why I think the legislature would have did intend for this. Because, again, here the only people who voted yes to sell had none of their own property at stake. This statute is about winding down a condominium. It's about terminating it, closing on it. It's not about kicking people out, selling off bits and pieces. And the other aspects of the statute, I think, again, confirm our central premise, which is the majority owner is not the only possible buyer. This is one, the all means all is one of our arguments.
But wouldn't you be protected if, I guess, moving kind of to your other argument that there's a fiduciary duty to get the best possible price? If you get the best possible price and there's an offer and the parties agree this is the best possible price, then it would only require that the supermajority says we're willing to offer more than that. Then in theory, it's just the minority owners would be selling their interest, but at the best possible price. Wouldn't that still work with the whole property is not being sold?
So that would address one aspect of this, right? So you're right that if there were competitive bidding, if we really did determine what is the market price, that might address some of the financial aspects. But it's our position that this transaction never should have happened in the first place. Again, you shouldn't have people voting on selling other people's property, and that's why the statute requires selling all of the units and the common elements.
Well, but go ahead, Judge.
No, that's all right. But you keep going back to the statute.
Yes.
But these parties agreed when they bought this property and when it was sold that this could happen. This isn't the statute imposing something. This is something they voluntarily agreed to. They may not have read the contract, but the contract says it. How do I say that when two parties agree as to how this is going to work, that I should somehow say it's not going to work that way now? Because they incorporated a statute rather than just spell it out in the contract.
Because I think we have to look very carefully at what did they agree to. They agreed to the right of termination, which is not the same thing as sale.
Correct.
And then they agreed to incorporate the Condominium Act. And so that's why we have to look carefully at the statute. If the statute doesn't authorize it, then the parties didn't agree to the transaction. They did not agree.
But they did agree to the Condominium Act. So
Yes.
any unfairness in the idea that there's a sale that's going to occur doesn't really exist because they agreed to that.
Well, I have a couple answers. First of all, in terms of the statute, all they agreed to is to incorporate the statute, and so if the sale did not comply with the statutory requirements, then they never agreed to the sale.
Okay.
And as for I don't know if you're getting at our takings argument, but...
I am,
Okay.
because I don't see how there's a takings under this circumstance at all.
So in terms of the taking argument, when you incorporate a statute by reference or say that you have the powers under the statute, the only interpretation that makes any sense is the statute's lawful powers. If an application of the statute is unconstitutional, then saying you have that power under the statute does not give you the power of unconstitutional applications. And, I'll give you a couple...
So you're saying you can't waive constitutional rights?
There are some circumstances where you can waive constitutional rights. You can't waive constitutional rights that limit the power of the legislature by incorporating a statute from the legislature. Just like if you had a contract that says...
Well, if the CC&Rs weren't part of this transaction, then that say we're incorporating the Condominium Act, your client knew going in that it was subject to the termination, the Condo Act, right?
I think, there would be constructive knowledge at least.
I do have a question about that. Is it constructive knowledge about the Act as it existed? What if modifications of the Act transpire?
What modifications have transpired?
No, I'm saying what if they do? Does your client take it to the modifications or only as the Act as it existed at the time of purchase?
So I think modifications to the act can't take away rights because our clients only agreed to it as it existed at the time. I think it's possible the legislature could add more protections to the statute. That's obviously not in front of us today. But again, I think if you look at two condominiums, one where the declaration says the association shall have the powers under the Condominium Act, and one where the declaration doesn't say that, the association has to have the same powers, because by operation of law, an association always has the powers of the Condominium Act. So it can't be that one association in that example has greater powers, can exercise the statute in a way that is unconstitutional, and the other association can't. Because again, the Takings Clause restricts the legislative power. And so the Takings Clause says that the legislature cannot authorize one party to take another private party's property involuntarily.
So if it works out that your client were to get the fair market, that it goes on the market and the high bidder makes an offer and it's distributed in proportion to your client's interest in the property, do you agree then that your Takings Clause argument goes away?
No, Your Honor, because under Arizona's Takings Clause, just compensation is not available for takings for private use.
Even if you've agreed going in, your contract signed something saying, we know that if 90% of the condominium owners agree to sell, that this property is going to be sold. Doesn't that get rid of it? At that point, isn't it, you've now agreed, I get the argument that there's a duty to get the best possible price and you can't favor one party over another, but I'm not seeing how there would be a Takings Clause argument if it goes up to high bid and you get the high bid and that's distributed evenly. In your view, there would still be a takings?
Yes, because nothing in this contract consented to that kind of transaction. So I agree that you can contract around the Takings Clause, right? We do that every day when we buy and sell real estate. We are voluntarily selling our property because it's really clear that we're voluntarily selling our property.
I thought you were making an as-applied challenge. It seems to me you're suggesting just a facial invalidity of the statute. If you're saying under no circumstances can 90% of the owners say, we want to sell this, we're going to get the most possible money we can get for it, and everybody's going to get their share, you're saying there would still be a taking under that scenario.
So if the declaration spelled out, here are the circumstances in which the supermajority can vote to sell someone's property.
Doesn't the statute spell that out? And
the statute does.
And it's incorporated in the document they signed when they bought the property, no?
But if the legislature had no power to authorize this kind of taking under these facts, then the association can't have those powers merely by referencing the statute. Maybe they could if they had spelled out all the details of the statute in the declaration, but merely incorporating a statute by reference can't give you more power than somebody would have under the statute itself.
Counsel, your argument works great if they didn't incorporate it into the agreement. But we don't require, we allow incorporation by reference. That's something that's allowed every day. And in fact, in those real estate transactions you were discussing, they reference a lot of laws and incorporate them. So why is this different?
Because it's perfectly fine to incorporate statutes by reference. We allow that. Of course we allow that. But if the subject statute is unconstitutional and was outside the legislative power, then incorporating it into the statute and incorporating it into the contract has consequences. You can
so
only
incorporate. You are making a facial challenge. This is unconstitutional under any circumstance.
No, only as to certain types of transactions. Under our transaction, yes.
The termination agreement, the termination of the condominium is either constitutional or unconstitutional under your argument.
So I think there are a couple of possible constitutional applications, such as selling it to the government to build a library or to build a street.
That's here. Units by eminent domain. That's part of it. So they've already taken that into account. When would it be constitutional otherwise, under your argument?
I'm not sure. In making an as-applied argument, we don't have to show that there are constitutional applications. The difference between a facial and an as-applied argument is that in a facial argument, the defendants can win by pointing to a single constitutional
I'm just trying to figure out how I can say that as-applied here, but not unconstitutional. And I don't know how I'm going to draw that line. I'm trying to ask you to tell me how to draw that line.
Yeah, well, I don't think you need to resolve that in this case, because I think all that needs to happen in this case is that as applied to this fact, when you have less than 100% of people voting, when you have a private use on the other side, where it's being converted into private apartments, that is unconstitutional under the Cedar Point
Well,
case.
that's already out of the statute. Anything, it's got to be a private use here, because except the taking by eminent domain is already out. So your private use aspect really doesn't have bearing one way or another. Really, your only argument is it's less than 100% from my perspective. So if less than 100%, it's basically unconstitutional.
Yes, because again, the legislature does not have the power to give one person the power to take private property from somebody else. Before I run out of time, I'd like to turn back to the statute, if you'll permit me, although I'd be happy to answer more questions on the takings clause. Again, this central error of presuming that there's only one possible buyer is what caused a lot of these errors. It's what caused the association to favor the interests of Dorsey Investments over the other 6 unit owners. The association that has fiduciary obligations has those obligations to the unit owners in their capacity as unit owners. And in this case, the unit owners are selling property. But Dorsey Investments' interests in this case were only as buyers, because they were not sellers. They were not selling any of their own property. So I think it's really clear that you can't favor the interests of the person on the other side of the transaction when you owe fiduciary obligations to the people that are selling the property.
Are we imposing some sort of minority shareholder rule here?
No.
Is that what you're asking us to do?
No, absolutely not, Your Honor. I think under really basic principles of trustee law and fiduciary law, you have to favor the interests of the people in their capacity as beneficiaries. And in their capacity as beneficiaries, they're sellers.
See, how does it work then that they don't become trustee until after the termination agreement is complete? They don't know what fiduciary duty before that.
Well, first of all, condominium associations always owe fiduciary duties. I think that's an error in this case. If you look at Restatement 3rd of Property Servitudes, Section 6.13.
But does one condominium unit owner owe another condominium unit owner a fiduciary duty?
No, but the association does.
But then do 80% or 94%, I think it was in this case, do 94% of the unit owners owe the other 6% a fiduciary duty?
Not in their capacity as owners,
so they
but
can
they
vote
do
the way they choose to.
Excuse me?
So they can vote the way they choose to.
Yes.
So the fact that they're also a purchaser doesn't create a fiduciary duty between them.
No, but the association owes the duty.
But it's the shareholders of the unit owners, the ones who are voting, not the association.
Right, but the association has an obligation, again, in its capacity as a trustee and its capacity as a fiduciary, to determine who is the best possible price, who makes the best possible offer. You can't just assume. Nothing in the statute allows the association to assume that the majority owner will be the only possible buyer.
And isn't the cure to that the fact that each unit gets to have an appraisal? In fact, a second appraisal if they don't like the first one, to determine what the fair market value is and get the money they're entitled to.
No, Your Honor, because we all know that in market transactions, you don't always get the appraised value. When you go out and sell it to the market, you might get more, you might get less. The whole structure of the payout is based around taking the lump sum of the proceeds, distributing them proportionally based on those appraised values. Those appraised values are the inputs, not the end product. I'd like to save just a couple minutes of my time for rebuttal, if you'll permit me.
All right, thank you. Counsel.
Thank you, Your Honors. May it please the Court, my name is Nick Nogami. I'm from Carpenter, Hazelwood, Delgado, and Berlin, and I represent Dorsey Place Condominiums Association in this matter. Your Honors, I would posit that this is a fairly straightforward case about a condominium development that was terminated pursuant to the agreement of the owners within the development. Just to back up just a little bit here, I like to think of condominiums. The easiest way I can sort of conceptualize condominiums is it's just a big house that a bunch of people live in, pursuant to an agreement between them. And that agreement is essentially the declaration or the CC&Rs. In this house, everybody gets a room and agrees to chip in for the common expenses and pay accompanying assessments. There's other terms in the agreement that talk about how everyone will conduct themselves, how insurance will be paid on paid for on the common areas, what laws apply to their setup, etc. And
Counsel, can I cut to the chase a little bit? They've agreed that 90% can decide to sell the property, but they haven't agreed that the price will be whatever the 90% want it to be. They've just said the proceeds pursuant to the statute of the sale will be distributed in proportion to their respective interests. And the only thing that's been decided by a pre-termination appraisal is their respective interests. And my basic question, if the property sells for $5 million more than the appraised value prior to termination, what happens to the $5 million? Does it go to the 90%, or isn't it distributed according to the respective interest of the unit owners?
I believe it'd be the latter, Your Honor.
Well, so doesn't that then create a fiduciary obligation on the part of the association? Once you've decided 90% say we want to sell it, and if we can get $5 million more than what one person is offering, how is there not a fiduciary duty to sell it for $5 million more? That doesn't make sense?
Well, no, Your Honor, I was just thinking, Your Honor, and I'll tell you that my general premise in the situation is that the owners within the development are the ones that dictate exactly how the sale, how the termination proceeds.
But all they dictated is a minimum amount. They've said, we'll all agree to sell if we can get at least $5 million for this. But that doesn't dictate that they won't take more, and in fact, it would be odd to suggest that they wouldn't want to get a higher bid.
Correct, Your Honor. And I'll say that my position on that would be that the association's role as a trustee, or their role in the sale process, to the earlier question, comes after the agreement to sell and the termination agreement that has the terms of the sale.
But the termination just says there's a floor. It says the minimum amount that we'll accept. So you're saying all they're doing is they're just holding it, and we have no obligations to the minority unit owners. It's whatever the supermajority says is the best price for this. Why do they call them a trustee? Aren't there some fiduciary responsibilities that go with being a trustee?
Well, I think that the role of the trustee here, Your Honor, is spelled out in the sense that it is designed, the trustee's role is to effectuate the sale as agreed upon by the owners.
But what if they agreed to more than, this is the minimum amount we'll accept?
And then the suggestion is that the association goes out and markets the property and tries to get additional funds?
Well, there might be some alternatives, but at a minimum, shouldn't they get a post-termination appraisal if there's some indication that this property could be converted for something else? The Arizona Diamondbacks want to use this property for something, and here we have an indication that somebody thinks the property could be worth more as an apartment. Isn't there some obligation to find out, well, what is this worth as an apartment? If we're selling it, we're saying this is the minimum we'll take. Isn't there a fiduciary obligation to at least get an appraisal, if not put it on the market?
Well, there is an appraisal obligation in the statute, Your Honor.
The appraisal, though, is pre-termination.
Right.
So that's before we know there might be another use for the property.
Right.
Now you've agreed to sell it if we can get this amount.
Right.
At that point, if you're selling, don't you have to go out and see what's the most we can get for this property?
Well, I guess the proposition there would be tasking the association with that duty. And I don't see where that duty would be established anywhere in the statute or anywhere in jurisprudence or anywhere else. I guess that's my situation here, is that my position would be the association acts as a trustee to effectuate the sale that the owners had agreed to.
But the owners haven't agreed to anything other than a minimum amount.
Well, I think if you look at the condo termination agreement here, Your Honor, I would say that the terms of the sale are fairly well established. And then from there, the association's role is to carry out and do what it can to effectuate the sale of pursuant to the terms that the owners have agreed to. So I don't see where there's an independent duty for the association to then go out and look for other buyers or market it. I believe that the association's duty as trustee is to carry out and effectuate the terms of the sale that the owners have agreed to.
And you're saying that's completely spelled out. Sorry, go ahead, Judge Gus.
Well, I just want, because we keep talking about the pre-termination value, but doesn't the statute actually say, an independent appraiser selected by the association shall determine the total fair market values? Now, total fair market values could actually be based on this as it becomes an apartment. There's nothing that restricts, and in fact, the unit owners could say, no, we think in the second, they come in with their appraisal, they say, we want this appraised as an apartment complex, not as a condominium complex, and then it goes to arbitration to settle what the actual total fair market value is. Fair assessment?
Yes, Your Honor, I believe that's accurate.
So in other words, it's not just...
Hold on.
Go ahead.
Because he read the second sentence, but not the first. And the first sentence says, except as provided in paragraph 2 of this subsection, the respective interests of the unit owners are the fair market values of their units, et cetera, immediately before the termination.
Correct. And that's how we allocate how much money each person gets. I've got a unit, you've got a unit, you've got 2 bedrooms, I got 1 bedroom. I'm 1%, you're 1.5%. But then the second sentence is independent, and that's the appraisal. And that's not limited by that first sentence. So where the first sentence just decides between the unit owners, how much each unit owner gets. The second sentence says you need to establish fair market value. Is that fair?
Yes, Your Honor.
So isn't the real issue here, and I acknowledge that I'm just sort of coming to this, but isn't the real challenge then, did your company or your client actually get a fair market value assessment, or did it have it assessed as a condo unit?
Well, wouldn't that go to the fact that if there is a dispute on that issue, that there is an appeal, there's essentially appeal rights built into the statute that the appellants here did not avail themselves of. So I don't even know that that issue would necessarily be.
No, I understand, but isn't that the way it can work?
And just to make sure I'm clear, so you're saying that you agree with Judge Goss' assessment, that, I mean, let's be clear, you are conceding before this court that, as you say, an independent appraiser selected by the association shall determine the total fair market values. So you're saying that that fair market values would include a condo transforming into a apartment building. The value of the unit of a condo
And I'm not saying that it always shall. It depends on the facts of the case, because fair market value is always going to depend on that. I just want to be clear on what I was saying.
And I would like to interrupt if you want.
Well, let him answer the question.
I'd like to have, after counsel answers.
Respective interest of the unit owner, the fair market value of their units. And I'm sorry, was the question whether or not the fair market value determination would need to consider both as a condominium and as an apartment complex?
Right, the value of that unit is a condominium versus an apartment.
I see. And so the question is whether or not the association has the duty to independently explore that option.
No, whether the way I understood Judge Goss's question was, if you're getting an independent appraisal, is the appraisal taking into account the conversion, or is it just, what is the value of this as a condo?
Oh, I see. You mean as I would understand it, and as I understand it would play out here, Your Honor, I believe it would be the value of the unit as the condo as it was valued prior to the termination.
And isn't that precisely what the statute says? The fair market values of their units, not of the overall thing as in some other context.
Right.
And I'm having a hard time reconciling it with paragraph D that says proceeds of the sale shall be distributed to unit owners in proportion to their respective interests. So I'm not understanding how their respective interests are determined by this pre-termination appraisal, but that's clearly not dispositive as to how much they're going to get when it's sold. Under D, it just says that the actual proceeds, so if it sells for $5 million more than what the appraised value was, the proceeds are distributed in proportion to their respective interests. So I'm not following how the respective interest means anything more than my interest as compared to other unit owners, not the actual amount I'm going to get when it's sold.
Well, and again, and I apologize if I'm just missing this line of questioning. If I am, feel free to correct me. But I guess what I'm trying to understand is, are we questioning what the association's role is here in this process? I mean, if it is whether or not the association has a duty to go out and seek something beyond what is provided for in the statute with regards to appraisals, or is it a disbursement issue? Because I don't know that either of those are real issues before.
Well, I think there's an issue because the association is a trustee, and the termination just it fills the role of a trustee, and all the termination agreement does is set a minimum that we're willing to accept. So I don't know how you just jump to, let me just offer a hypothetical where it's not Dorsey, it's individual owners, and there's 90 of them, and they say, we don't like the restrictions that the condominium complex currently has, where we don't allow people to rent for less than, sublease for less than 6 months. We want to turn this into a VRBO. So we're going to get rid of the condominium agreement, and we think there's 5 units that are particularly profitable, and so we want those units. Do they get to just say, we're buying, that 90 of us are getting together and we're buying out 5 people that we don't like, that don't want to have this as a VRBO? Can they do that?
And again, I apologize if I'm missing this, Your Honor, but are you just asking if those 90 owners, if they wanted to initiate 33-12-28,
Right.
and essentially, and again, I guess that's very much akin to what's going on here, I suppose, although there'd be 90 separate owners. But is that the only distinction between this case and the hypothetical?
They can then come in and say, we're only buying these 5.
The 90 individuals
Right.
would say that they are going to buy the remaining
At a price
5?
that we set. We don't care that someone else might pay more for it. We've just decided 90 of us want to buy out 5 other owners, and we're just going to rent them to somebody else, but we can do that under the statute. It seems to me the statute contemplates the owners agree we want to end this agreement, and we think we can sell this property for more than the appraised value, and we would all benefit equally. I'm not getting from the statute this right that one unit owner, it doesn't bother me that they're the purchase owner, but if they're going to purchase it, they have to purchase it at a price that's fair not only to the other unit
Is there a
owners, but to
question?
them.
Is there a question?
No, it's just a
before we-
statement.
No, I know. And I was
Rant on, Judge Goodwin.
Let me ask you this. Isn't the cure when a person thinks they're not getting enough money, for whatever reason, to say the fair market value is in fact higher and I'm getting another appraisal? And if the appraisal comes in more than 5% above what the other units are saying, then it goes to arbitration and it gets resolved. Isn't the fair market value and the appraisals the cure to the problem that we're talking about?
Yeah, Your Honor, that'd be my position as well.
And it's still allocated the same. If they come up with, no, it is in fact the $5 million more, then each unit is going to get its percentage of that $5 million based on that pre-termination valuation of what each unit's percentage. It's not the value that we're determining, we're just determining the percentage each unit gets.
Correct, Your Honor.
Okay.
But in your view, once that value is set, there's no right beyond that.
Well, no, it's not necessarily that there's no right, Your Honor. I guess I'm just, the issue, and the question is whether or not the association has the duty to go out and solicit additional buyers, or what the association's duty here is, and I believe that would be spelled out in the declaration, or sorry, the statute, and then the accompanying termination agreement, which is the owners dictating to the association how to effectuate the sale.
Well, it says they get a buyer, and then it has to be agreed to by at least 90%. So doesn't that contemplate them doing something other than just signing off on? It seems to me there's some fiduciary obligation there, but I guess I'm on an island there.
No, Your Honor, I understand your point, Your Honor. I will say that Arizona jurisprudence actually hasn't assigned a fiduciary duty to community associations in Arizona at this point. The duties by community associations to individual owners are laid out in the restatement. They've been kind of codified a few different ways.
But why call them a trustee in the statute?
Well, the purpose of, I guess their role as a trustee here, and again, this is just sort of basic trustee law, is laid out in the statute that their role as a trustee is just to effectuate the, I don't know if you're going to call them desires, or the terms that have been agreed to by the owners pursuant to the termination and sale agreement, whatever they come up with.
I just have a follow-up question on my thing, which is, it occurs to me then, following the logical line of my reasoning that I'm articulating, not necessarily adopting. But then if they went to arbitration, it would be subject to the Uniform Arbitration Act. Wouldn't that be fair? It's not just any arbitration, it's arbitration under the Act, and all the protections for people in the arbitration would be there, including being able to take it to the Superior Court to challenge the outcome.
I believe so, Your Honor.
I don't know how else to read it, I just wanted to ask that question. Not necessarily relevant here, but that's fine.
If I could just follow up on
No problem.
the pre-termination appraisal. Let's say somebody thinks, gee, the Diamondbacks might want this as want the land, and they're willing to pay a whole bunch of money. In that instance, it's kind of nonsensical to be talking about the specific value of the individual unit. They're presumably going to bulldoze everything. So I guess I'm having a hard time reading this as being anything other than just the value as a condominium and the value of my unit before it's terminated.
You know, I think what it would be is that without a little bit more specific guidance here, I think what the association would be tasked with doing is undertaking a reasonable appraisal process to envelope whatever we're talking about, whatever evidence or information they may have. They have to go out and get a reasonable appraisal of the process here. And again, that would be the duty that is assigned to associations when there are discretionary decisions to be made under the law. But again, I don't know that that was raised here. I don't know that there was much discussion at the lower court about the appraised value. Again, the appellants did not actually avail themselves of the appeal rights with regards to the appraisal of the units. So
But it's a fair market value of the property.
well,
That's what the statute says. It doesn't say
right.
of the units, it's a fair market value of the property. So if the Diamondbacks are in there bidding on it, that's also part of a fair market value assessment.
I would think in theory, sure, Your Honor.
And if they ignored that, then you would have a different claim.
Yes, I would love the Diamondbacks to move in there. But again, that's not necessarily in front of the court today, but yes, I believe that would be part of it, is if they said, well, you ignored this solicitation by the Diamondbacks or whatever else it might be, yeah, I don't know if that would be a reasonable exercise of discretion on the part of the association. Do you mind if I move on quickly, I think? Just some other matters. Stone Shaw, who was a party to the underlying action, has not been named as an appellant in this appeal. Accordingly, his claims have been abandoned. I would like to touch on the fact that the judges did recognize that this has been framed as an as-applied challenge, but I believe that is only being framed that way to avoid certain procedural issues. It's clear this is a facial challenge to the statute, and therefore ARS 12-1841 does apply. I believe that it is the language of the statute on its face that is being challenged here. There's nothing about the challenge being made by the appellants that is unique or specific to this fact pattern. And in fact, frankly, if the appellants were correct about their challenge to the statute, it would call into question literally thousands of condo terminations across the state, making this a clear case of a facial challenge. So just saying that the appellants are bringing this challenge for their own purposes or interests, but meanwhile contesting the statute's general application language, does not suffice to make this an as-applied challenge. Therefore, I believe that this is a facial challenge, and the requirements of 12-1841 needed to be complied with before it could be heard, which was not done, and therefore the challenge should be dismissed until such compliance occurs.
But they are specifying under these circumstances where it's sold to one of the owners without putting it up for bid. That as applied there, it results in a taking. Notwithstanding whether they concede or not that it still would be a taking. Doesn't that turn it into an as applied?
Well, it would be if there were anything unique about it, but to your point, they are discussing generally that they cite specific language of the statute saying this provision is unconstitutional, this provision is unconstitutional per se, essentially. So that would make it facial. There's nothing independent or unique about the notion of selling to a majority unit owner.
Unless it's sold without entertaining any other offers, I think is what they're saying is unique.
All right, thank you. Your time has expired.
Thank you, Your Honors.
Honors, I just have a couple of quick points following up on that. Your Honor, to your question about other possible buyers and so on, this statute contemplates a bona fide sale. Otherwise, the majority could agree to sell other people's units for $1, right? You said at whatever price that they want.
No, they have to get a fair market value appraisal, and they have to do it for the appraised value.
And if they came back with just $1, then your client could say, no, I want a real appraisal, and it would move forward and at the association's expense.
But the appraisal would only determine the respective interest, which is how you divide up the dollar.
That's not what that says. The first sentence says it's the allocation of the individual interests. The second sentence clearly is the appraisal and is different. And that's where we get into the, I'm sorry, I moved down into the wrong section. Let me move back down into that. No, I'm not going to find it. Yeah, here it is. It's the first sentence is, except as provided in paragraph 2 of this no, I'm still in the wrong section.
Your Honor, if I could help, if you're in subsection G, that's talking about the mechanics of the appraisal, but the distribution of the funds is actually in subsection D in the middle of it, where it says proceeds of the sale shall be distributed to unit owners and lien holders as their interests may appear in proportion to the respective interests.
Right.
So that the sentence...
The respective interest is based on the value of their condo, as compared to all the other condos.
Yes.
So my condo's worth 100, yours is worth 100, we both have the same respective interest.
Yes.
So when the sale happens, we're both going to get the same amount plus 5% under the statute.
Right.
But that has nothing to do with fair market value. That's what it's going to sell for. And in your scenario, when you're not having, a fair market value is basically considered a sale in the open market, not a sale to some one buyer. So the appraisal, isn't your real issue that the appraisal wasn't sufficient and your client didn't get a second appraisal?
No, because the appraisal right doesn't cure the fact that this transaction never should have happened in the first place. I see what you're saying in subsection G, but that does not, subsection G is not about what gets paid out. Subsection D is about what gets paid out. I'm running out of time, so if I can just say one more thing.
Your time has expired. The case is submitted. We'll issue a decision in due course.